Hi, I'm State Treasurer Dennis Milligan.
And I'm Nate Coulter, Executive Director of the Central Arkansas Library System.
Thanks for joining us for our 4-week financial education series, a partnership between your State Treasurer's Office and the state's largest library system.
We've teamed up to bring you 4 presentations about financial education. We're honored to have some local experts join us to provide these sessions, which will cover a wide range of topics.
That's right, Nate. We'll start with understanding the basics, learning how to develop a budget, then move on to managing debt, saving for education, and saving money for your yearly taxes.
But it doesn't stop there. We'll also look at how making plans now can help you later with some of life's major changes, like marriage or divorce, dealing with an illness, or the sudden loss of a loved one, to caring for an elderly parent. There's a lot to consider.
There is. In the end, we hope these sessions inspire you to take control of your finances, no matter what your economic situation is.
And we hope these sessions and our presenters educate and encourage you to keep learning, no matter your age.
Thank you for joining us. Let's get started.
Let's go.
All right, let's get started. Thank you all for joining us tonight. I'm Mark Christ, Head of Adult Programming with the Central Arkansas Library System, and I'll be moderating tonight's session, which is Planning for Major Life Changes. It'll be presented by Kevin Brunson of the Wilson Estate Planning Group. Before I hand it over to Kevin, I got a few housekeeping items. Everyone will be muted during this presentation, but you can put your questions into the chat, and when Kevin finishes his presentation, we'll get on those. During a break or at the end, I'll be sure and ask Kevin those questions. Tonight's session is being recorded, and as with the other 4 programs in our financial literacy series, it'll be available both at the CAL's YouTube channel and on the Treasurer of State's website. With that, I'm happy to introduce Kevin Brunson. Kevin is the supervising attorney for the Wilson Estate Planning Group. His practice focuses on estate planning, estate and trust administration, elder law, and business planning. Kevin has worked in law firms since 2003 and began working as a paralegal in 2006. While working, he completed his undergraduate degree in history from the University of Arkansas at Little Rock in 2013. And he graduated from the UALR's Bowen School of Law and received his law license in 2016. Kevin is licensed to practice law in Arkansas and is a member of the Arkansas Bar Association. Having worked in the fields of estate planning, estate and trust administration, and elder law, both as a law clerk and since 2015, and then as an attorney, Kevin accepted the position with the Wilson Estate Planning Group in January of 2018. In his spare time, Kevin likes doing anything outdoors, spending time with friends and family, and frequent travel. And I think also talking about major life changes. Kevin, take it away.
Hello, everybody. Thank you, Mark, for that introduction. Thank you to the Treasurer and to the Central Arkansas Library System for having me here today. And thank you for everybody attending to listen. What I have been, I need to share my screen real quick. Okay. Is that showing up correctly, Mark?
No, it's not the full.
How about now?
There, now,
is that better?
we're
okay. So thank you again for having me here. The topic for tonight is going to be estate planning for major life changes, and that involves a whole bunch of stuff. So if I go a little too quickly, please enter into the chat and tell me to slow down a little bit. Mark, if same thing to you. If I go a little too fast, tell me to slow down. What I thought I would do, and what I think that Mark and everybody said was appropriate, is to start with some basics of estate planning first, and then talk about how that estate planning works into the different stages of your life and major life changes. So the first thing I'm going to start with is actual estate planning, which is a combination of legal documents and legal procedures, and also financial products, assets, and all of that kind of stuff. So by the end of this, you'll understand a little better how all of that interacts and how that coordinates together. So estate planning 101. First off, what is an estate? The first thing that most people have come to mind is that that's what happens after I'm dead. That's all my stuff after I'm dead, or there's an estate sale down the street because the lady down the street passed away. The truth is your estate, which is your assets and everything that you own, business interests, your home, your IRA, your 401k, all of those things. It exists during your lifetime, during your incapacity, and also following your death. So proper planning is going to plan for all three of those different situations. But how do you do that? There's a whole bunch of questions that you have to ask, and every estate plan is going to be customized to the individual need of the person or the couple needing it, depending on relationships with children, depending on whether your children have supplemental needs and things like that. But essentially, we want to be asking lots of different questions. Some of the basic ones are, who's going to make the financial and medical decisions for you if you're not able to do so? Who's going to run your business if you have one, if you're not able to? Who's going to care for your minor children if you're not able to? That's a really big one. And where will your assets go following your death? And who will distribute your assets after your death? Those are some of the questions, but like I said, they're very customized and factual to the individual or the couple. So estate planning can bring peace of mind, not only to the person who is establishing their estate plan, but also to loved ones. Peace of mind knowing that if something happens to me, if I'm incapacitated or if I pass away, there is a roadmap forward. There is a written map forward as to what to do. It will provide security for your loved ones, knowing that they can be taken care of. But it also, when you're going through the declining health of a loved one, or after somebody passes, there's that grief fog that lots of people experience, where they're just not able to function and they don't know what to do. Well, if you've written it down and made a concrete road forward, there is a lot of relief there for your loved ones. I'm not going to go through all of these different changes in lifetime, because I've covered some of them later in the presentation. But as you can see, life doesn't always happen in order, although this is the typical kind of order it will happen in. And your needs, your estate planning needs, change over time. So we want to make sure that we are adapting and updating your estate plan as you go. So there are two core principles in any foundational estate plan. The first one is going to be avoiding guardianship, and the second one is going to be avoiding the probate process or estate administration. And I'll talk to you about all of that. Well, let's start with a guardianship. What exactly is a guardianship? It is a court proceeding where, let's pick on Mark because he's sitting right there. Mark is not able to make his healthcare or his financial decisions for himself. And so maybe his wife or a relative would go to court and ask the judge for permission to be able to make those decisions for him. And that is a public record. So you can hop online to the Pulaski County Pulaski County Clerk's website and look at the different entries in there. Some people would be a little horrified to know that somebody is putting in the public record that, I'm not able to make those decisions for myself anymore. I know my grandmother probably would be, and she would punish me appropriately. There are two types of guardianships in Arkansas. One is over the person, which is making healthcare and well-being decisions, and then guardianship over the estate, which is over your property and your finances. So as you will see or hear several times in this presentation, just keep the mantra going of time, money, and headache. So a guardianship takes time. You have to go to hearings. You have to, the time it takes to do a guardianship it's as long as it's necessary, as long as it's needed. It can be multiple years. There's annual reporting that you have to do, telling the court what you've spent money on, and making sure that you've not done anything, inappropriate with the assets. And there's a lot of money involved as far as paying attorneys to go to court. Yes, you can go pro se, meaning represent yourself, but it's going to be most appropriate to have an attorney with you. And a headache. It is a lot of hassle, and it's a lot of stuff that you do not want to have to deal with. So, an example of a guardianship would be Britney Spears, the pop star back in 2007. She had some mental health issues, and her father wound up getting what's called a conservatorship, which is what they call it wherever they live. It's the same as guardianship over her estate. I'm not sure if he got a conservatorship over her, her person, her health. but he did take over her estate. He managed her money for a good long time. And I think she's actually in the process of trying to get that lifted so she can be back in charge of her stuff. So the point is, how can you avoid having a guardianship? It's very simple. You have powers of attorney in place for your finances and property, and have a power of attorney for your health care. That is designating a person or people, or in the example of the guardianship over your finances, you can actually appoint a corporation or a bank of some sort to act as your agent to make those decisions for you if you're not able to do so. And if you have those documents in place, they're just documents. They're pieces of paper that take a few minutes to execute. You will avoid that time, money, and headache of having to go through a guardianship because you have people in place to do that. You don't have to ask the court for permission. So the second core principle and thing that you want to avoid in an estate plan is the probate process. So the next question is, what is probate? So the word probate actually means the process of proving a will valid. So a will is the document that you write down. This is the person I want to handle my estate, my stuff after I pass away. These are the people I want to get my stuff after, the court is done with me. And you take the will, you admit it to the court and ask for permission to probate admit it to probate and prove that will valid. Estate administration is a similar process to probate, except for you don't have a will. So you're going to the court and asking for permission to administer this estate. Well, we don't know who the beneficiaries are because you didn't list them in the will. We don't know who you would want to make in charge of your estate. And so it's probably going to be whoever is the most appropriate person that the court determines. Well, if you haven't outlined in your will or some other document, a trust maybe, who you want to get your stuff, the state actually has in the statute book, it has a list of people of basically who is going to get your stuff. Those are called your heirs at law. So if you do not want your heirs at law, who the state says is going to receive your property, then it's best to always have it written down in a will, because it could be that crazy cousin you haven't talked to in 20 years who has a meth habit or something like that might wind up being your heir at law, and you do not necessarily want that person to receive your property. So here comes the time, money, and headache aspect again. So probate can, an average probate will take between 8 months and a year. It involves a 6-month creditor claims period where you've posted notice in the newspaper to unknown creditors, given specific notice to real creditors that you know of, and you wait 6 months for them to file claims against the estate. You have to haggle with them over what they're going to settle for. Then you have to petition to distribute the rest of the assets. Again, it's a court procedure where you're spending money with attorneys, and it can be a real headache. It can take a really, really long time. So the question is, how can you avoid probate? There are 3 very basic ways to avoid probate. The first one is going to be having beneficiaries designated on your assets. Life insurance can have a beneficiary designated. Your 401k can have a beneficiary designated. I'll get to it in a minute, but your house can even have a beneficiary designated on it if you need to. There was the beneficiary designation. Then there is joint ownership with rights of survivorship, which basically is, let's take an example of a husband and wife who own a home together. They own it as husband and wife, which is a joint ownership with rights of survivorship called a tenancy by the entirety. That means that the collective married couple owns that property together. So if one of them passes away, it automatically belongs to the other one. You can also have joint tenancy with rights of survivorship with a different individual, but you have to specifically say that in the deed to the property or on the asset. If you don't, then the automatic default in Arkansas is going to be what's called a tenancy in common, where let's say 2 people own this property. They each own an undivided 1/2 interest in this property. And if one of them passes away, that person's probate estate would have to be opened in order to transfer that asset to whoever's going to buy it or transfer it to, whoever. So there is the beneficiary designation, joint ownership with rights of survivorship, or your assets can be owned by a trust. So, and I'll get to a trust here in a second. So Arkansas also has what's called an affidavit of claim for a small estate by distributee. And that is an abbreviated probate process where if your assets or the assets are less than $100,000 in value, it could be a $250,000 house that you have a $151,000 mortgage on that still qualifies for a small estate. If you have real property in the estate, meaning a house or land, you have to publish in the newspaper a notice to creditors like you do in a probate process, but it is a 3-month claim period as opposed to that 6-month claim period under probate. So after the 3-month period, you deal with creditors. It's going to be best if you know that there are creditors to open a regular probate instead of a small estate. There's not a lot of case law out there defining how to deal with these small estates. If there is not real property in a small estate, then you get the certified copy of this affidavit that you fill out saying various other things. I don't need to go into too many details on that. You get the certified copy, you go down to the bank. That day you can get control of that bank account. It's that easy. So avoiding probate would be beneficiary designation, joint ownership with rights of survivorship, or ownership by a trust. So there are some essential estate planning documents. Either you're going to have a will-based plan or you're going to have a trust-based plan. If you have a trust-based plan, you're going to have what's called a pour-over will, which is a spare document. You want to make sure that your assets are owned by this trust, payable on death to this trust. But if you have something floating around out there that you didn't have that joint tenancy with rights of survivorship or beneficiary designation or ownership by the trust, that will would be probated to get that asset poured into your trust. Otherwise, a regular will-based plan will be your last will and testament that we discussed earlier, says who you want to be in charge of your estate and where your stuff goes. Then we have the general durable power of attorney. That's the one over your finances and property. Then you have your healthcare power of attorney. Those are the two documents we talked about earlier that help avoid guardianship proceedings. You designate the people to make those decisions for you. Then you have a HIPAA authorization, which is a document where you designate who you want to have access to your protected healthcare information, whether that's your talking to your doctors, getting access to your medical records, and that sort of thing. Your agent under your healthcare power of attorney will also normally be your HIPAA agent, but you can specifically name other people that you don't necessarily want to make decisions for you, but you want them to have access to that information. If you're in the ICU, get an update from your doctor, that sort of thing. You can also specifically say who you do not want to have access to that information. So sometimes we have people that we absolutely do not want to talk to our doctors or have that information. The very last document will be a living will. You may have heard of it called an advanced directive in other circumstances. But this document says that essentially, and please don't quote me because the actual document does not say exactly this, but if you are in a permanent condition at the end of your life and you cannot in any way indicate what your end of life treatment should be, meaning you can't blink an eye or wiggle a pinky, it says that you do not want life-sustaining procedures that would keep you in that position. An example would be, I have stage 4 cancer, I'm in a coma, they say that I need a feeding tube. Well, that document would say, please don't give me the feeding tube. There is the ability to build in a little bit of flexibility where the agent under the healthcare power of attorney can override the living will, whether it's temporarily or permanently, to say, you know what, let's give that feeding tube and see if he improves. And if he does, that's great. If he doesn't, we'll honor his wishes. So those are the foundational documents. So, okay. So what I mentioned earlier about, I'm sorry about this one being a little blurry. I didn't have a way to be a little more clear. We talked about assets that avoid probate have beneficiary designations, are jointly owned with rights of survivorship, or are owned by a trust. This is contemplating the cost of probate for assets that do not have any of those options on them. So a life insurance policy that does not have a beneficiary on it, a home that is owned by somebody that is not jointly owned or does not have a beneficiary deed associated with it. As you can see, let's say the $200,000 mark, there's a filing fee of $165. If it's an e-filing county, there's a $20 additional fee on top of that for the technology. Then we have the personal representative or the executor's fee. This is under a statute, meaning it's a law book you open and you do this calculation, you know, X% for the first $1,000, X% for the next $3,000. of the assets that need to go through the probate estate, and it winds up being this $6,150. That amount can be higher or lower depending on, depending on the personal representative's efforts. If they're extraordinary efforts, it can be more. The personal representative, sometimes it's a spouse or a child or the only beneficiary. They don't need to be paid from the estate because they're going to be the beneficiary of the estate, so they can waive that as well if they want to. The attorney's fee is similar to the personal representative's fee, as it is a statutory fee. You open the law book, do that calculation, and it comes up to this. Frequently, attorneys will take an hourly basis for probating, going through a probate estate, because you just never know what's going to happen, who's going to pop up, what kind of trouble there will be. But this is the statutory amount if they elect to go with that. And as you can see, for a $200,000 estate, that's $12,365 worth of costs associated with it. If you had the assets jointly owned with rights of survivorship, with beneficiary designations on it, or in a trust, you can avoid this cost altogether. So this is the cost on one death. So there's the possibility, if it's a married couple, that this will have to happen twice. So you can save 24,600 and whatever 65 times 2 is on that estate. So as you can see, that's about 6.1% of the amount of the assets that have to go through the estate. That's pretty expensive. It can be. And it can always go up from there. So what exactly is a trust? So I try to explain it in a kind of a digestible way. Conceptually, some people just don't get it. So I try to explain it in a digestible way. It's an agreement. It's like a contract. You have a trust maker, who's the person making the trust. You have the trustee, who's the person that's going to manage the assets and be in charge of everything. Typically, if we're doing a regular revocable living trust, it's going to be either you and your spouse are going to be the trust maker, and you and the spouse are going to be the trustees. So you would be making the trust, putting your assets into it, and also being in charge of everything. You can set up your successor trustees after you if you need to. These trusts can be joint or individual. So a married couple can have a joint trust. They can also have separate trusts if they, have separate, property that they want to make sure is managed separately. It's kind of similar, this agreement is kind of similar to the bylaws of a corporation or the operating agreement of a limited liability company. It's an agreement, and it lays out the instructions on how to operate the trust during your life, during your incapacity, and following your death. There are different types of trusts for different type of purposes, so it's not always going to be that revocable living trust, but for our purposes, we're just going to be talking about that. It is a probate avoidance technique, among other things. So sort of like when I was talking about bylaws of a corporation, let's say Walmart. Walmart is a giant corporation all around the world, and they own property all around the world. This is a corporation, an entity that owns property. When you create a trust, you're creating an entity that can own property, have assets designated to it by beneficiary designation, and all of that. So you're creating an entity kind of like a corporation, but it is you on paper, and it avoids probate. Will-based planning versus trust-based planning. You can do anything in a will that you can do in a trust. It's just, if you do the will-based planning and you create a trust under it, you have to go through that probate process in order to create this trust. So all of those expenses we were just talking about, to create this trust. Here's that time, money, and headache mantra again. There is also, like the guardianship proceeding I was talking about earlier, it is a public record. So if, let's say my grandparents, they had a trust, and they also had a family farm. So that family farm didn't get properly funded or titled in the name of the trust. So what they had to do was open my granddaddy's estate to get his interest transferred over to my grandmother's estate after she died. And then from her estate, it got poured into the trust through that pour over will that I was talking about earlier. You can actually hop online to the Court Connect, is our local portal, and you can look up probate estates, and it'll say who is the executor, who are the beneficiaries, and frequently it'll say who's getting what and how much. And you wouldn't believe how many people come out of the woodwork that, like I said, that crazy cousin you hadn't talked to in 20 years. If they know what you're getting, they're going to probably show up on your doorstep and be your new best friend. So we've talked about the probate process. Well, trust-based planning has what's called trust administration associated with it. So after somebody passes, the successor trustee has to fill out some paperwork to be able to get control. There's the migration of assets from one trust to another trust, or one trust to the beneficiary, however it's set up. But that administration process can actually be very short. Sometimes it can be 2 months, sometimes it can be 5 months, but that's nowhere near 8 months to a year on a typical basis. It can be shorter or it can be longer depending on who causes trouble, who interjects, and who, just like I said, wants to cause trouble. However, trust-based planning is entirely private unless there is a lot of trouble and we have to get court intervention to get an order to make sure that it goes the way it's supposed to. It is slightly more expensive, and when I say slightly, I mean very slightly in the scheme of things, to set up a trust-based plan. And just as a blurb here, currently we have $11.7 million per person that you can have before. You've heard of estate taxes, you've heard of gift taxes. You can have $11.7 million per person in your estate without having to pay those estate taxes. So anything above that would get taxed for the estate tax. Likewise, you can give away $11.7 million worth of gifts during your lifetime. And so if you give away $700,000 worth of your of a gift, that means you can have $11 million still in your estate that you can pass on to your beneficiaries. That actually happened effective January 2018. In 2017, the exclusion amount was 5.49 million, which is adjusted for inflation every year, and it was adjusted. The 11.7 has been adjusted for inflation per year since then. That is actually scheduled to sunset, meaning go back down to the roughly 6 million per person, adjusted for inflation, January 1st of 2026. However, there's actually pending legislation in the federal legislature that is actually going to try to lower it sooner. There's one bill that is trying to lower it and have it retroactive to January 1st of this year. So lower it down to that 6 million adjusted for inflation this year. And the other one is going to have it effective January 1st of next year. So those are pending. We don't know what's going to happen, but there is a lot of planning that we need to do. So if you have, if you're looking at $6 million or you're looking at more than $6 million per person, come talk to me and we'll get that straightened out. You also need to understand that if a married couple each person has 11.7 million, you also have the ability to elect what's called portability. So I have 11.7, my wife has 11.7, and if I haven't used my 11.7, my spouse can elect portability and get that 23.4 million in the estate tax and gift tax exclusion amounts. So there is that option there as well. And when I was talking about just a little bit earlier about trust-based planning being slightly more expensive to set up on the front end, remember that you're still saving all of that money right there. And if it's a joint trust, you'll be saving it twice on 2 probates. So just keep that in mind. Again, this is the list of major life changes. We just wanted to kind of put these out there. These are not all of them, and I actually talked about some that are different than this, but I just wanted to put these out there for you to reference. The very first thing we want to do, we're transitioning from talking about estate planning basics. We're going to transition into talking about the different life stages and major life changes. Excuse me. And what we want to make sure and emphasize first off is that you need to review your estate plan annually so it'll work the way you want it to work when it's tested. So this last year, I'm sure every one of you has experienced all kinds of change, and there was a lot going on. So we never know what's going to happen. Taking a look at your plan annually will make sure that your beneficiaries are designated the way you want, your plan goes the way you want, your child who developed a drinking problem during COVID, because that's basically all we had to do for a year, that person can be protected. Their inheritance can be protected from their frivolous spending, maybe require them to get rehab or something like that to be able to receive distributions. Review it annually, it's important. What is the best thing that you can do for your loved ones prior to your death, other than your estate planning? That's a big question, and here is my answer to that question. Write everything down, everything. Please write everything down, and you see it in parentheses down there. Do it as soon as you're done with this webinar. Write down every password you have, every account number you have, your email addresses, your Facebook accounts, all of those passwords. Write them down, because that will make it so much easier for the person who is going to be your agent taking care of your business if you're incapacitated, and whoever's going to be in charge of your estate thereafter. I have two short stories. Hopefully they're shorter than I seem to be telling things today. One is a really good friend of mine whose husband died really suddenly. He was very healthy. He ran marathons, did all kinds of stuff. But then he had a freak four-wheeler accident and he died. Well, she would just give him money every month or every week or whatever. And he paid all the bills. He paid everything, the mortgage, all of that stuff. When he died, she had literally no record of anything. They had no paperwork because everything was electronic. She had no idea what his email addresses were, his passwords. She had no idea what the bills were. She had no access to any of that. Not that it takes an attorney to do so, but she is an attorney, so she was able to track down everything eventually, but it just took a really, really long time. Write it down so your loved one can take care of your business for you. The second story I have for you is actually a very personal story to me because it involves one of my best friends. He was diagnosed last year in June with a really, really nasty version of cancer. And so he was diagnosed in June, and we finally convinced him to do his estate planning. He signed on July 31st. And during the period after that, I was working to get his plan funded and do all of that. So I knew some of the assets, but I didn't know all of it. I didn't know everything he had. And of course, he doesn't really realize that he's actually going to die. So at this point, so he's kind of withholding some information so he can maintain some control over that. Well, he passed away on September 16th. So that is a really, really quick 3 months period. And when he passed, I had no idea. I'd been begging him to write all of this stuff down. And I even sat down with him to do it, and he just wouldn't do it. He would not write down all this stuff. Well, fortunately, a few years earlier, I had, those voice remotes with Comcast where you can click it and you say Netflix, and it pops up with your Netflix account. Well, I was watching him set that up on his TV. And so I saw his email address that he had entered in there. And I saw the password that he had entered in there. Yes, I used his Netflix password for a little while, but I do have my own now. I had his email address and I had his password. That password actually happened to be the password to his actual email. It happened to be the password to several different other things that he had going on, other accounts, his Facebook account and some other ones. So I was able to at least gain access to those accounts and those assets using those things. I also, a couple of days before he died, was fortunate enough to watch him type in the code into his phone, to the PIN number into his phone. And so I had access to the apps on his phone. I accessed all of that stuff. I knew he had a Facebook account. I could shut it down, all of these different things. Well, that PIN number turned out to be the PIN number to get into his computer because he didn't have a password. He had a PIN. It turned out to be the PIN number to his checking accounts and things like that. And also it was the code to his garage. I didn't have a key to his house, but I knew he left the garage door unlocked. And so I was able to get into the house that way. So just please always write it down and make sure that that's available to your people. It'll make it a lot easier, especially when they're going through that grieving process. They won't have to think about it and they won't have to fret about it. It provides that relief. So here's that first stage of life. We're going to talk about marriage or being coupled but not married. You're thinking about merging finances. So you have to be aware of assets and debts. Do we need to keep our assets separate, manage them separately? You want to make sure that you're thinking about powers of attorney and allowing for your spouse to be your agent under your power of attorney or not, depending on their situation. Just by virtue of being married, you create some rights in the other person's property. That is called the marital share. And the marital share is something that the spouse is going to be able to inherit whether or not they have been provided for in your estate plan. You also want to plan for the possible loss of income if somebody is deceased or becomes disabled. One available resource would be to get insurance that is sufficient to be invested afterwards to generate that lost income. You also want to plan for death or divorce. Do you want to plan for your spouse's possible remarriage? Do you want to protect your assets for your kids from the new spouse and possible division in a divorce or anything like that? There are different provisions we can put in there, including requiring a prenuptial agreement to be able to protect those assets. You also want to think about updating your beneficiaries. So if you're married and you have a 401k, even if you had that 401k when you started your career and you had your mom on there as the beneficiary, if you're married, there's a federal law that says that even if you didn't designate your spouse as the beneficiary, your spouse is going to get 100% of it unless they sign this waiver, basically, with the administrator of the plan. If they do sign the waiver, then it can go to whoever you've designated. If they do not sign the waiver, they're going to get 100% of your employer-based retirement plan. There's also something called the Secure Act, which was enacted in January, became active in January 2019. And it was a bipartisan federal bill that essentially, so this part of it has not changed. A spouse can actually get a rollover of your 401k or IRA and still receive the stretch out of the required minimum distributions over a lifetime. However, unless you meet certain requirements like a disabled child and some other things, whoever inherits that IRA or that 401k now has to take all of the money out and pay all the taxes on it within 10 years. So that can be problematic to a lot of people. So again, that can knock people into higher tax brackets, that can make a lot of money available to children that have drug or alcohol addictions. That can cause a lot of problems. So there are ways to confine that and restrict that and better manage that if necessary. So just need to talk to people and figure that out. If you're coupled but not married, lots of people decide to not get married. You're still dealing with merging finances or keeping them separate. There's not that issue of the marital share. And there's no control unless you have designated those people to your spouse or your couple, your partner, to make decisions for you for healthcare and finances and all of that. But after death, generally your partner is not your next of kin because you're not married to them. So those decisions as to release the body to the funeral home and that sort of thing, those cannot really be made by somebody who's not married to you unless you've made some planning. There's that loss of income thing that we were talking about. Maybe you get some life insurance that would accommodate that. For 401k, there's not that ERISA, which is the Employee Retirement Income Security Act, federal law issue. So if your partner is listed on that 401k as a beneficiary, they will get it. But there's still that issue with no spousal rollover on the employer or on the retirement account and no stretch out of that required minimum distributions. All that money has to come out within 10 years, whether it's in year 1 or a little bit over 10 years. So that's just an overview of that. The second stage of life would be purchasing a home or even a second home. So first thing we want to do is it jointly owned with rights of survivorship, either tenancy by the entirety that we were talking about between a married couple or with another person with those rights of survivorship specifically stated. There's always going to be the possibility of a probate on the second death unless we've taken care of it otherwise, owned by a trust or maybe a beneficiary deed, which I'll get to in a second. Do you own a home or property in another state? This is where you will definitely need to have a trust in place. There's the possibility of a double probate. So if I own property or live here in Pulaski County and I own property in Florida, vacation property on the beach in Florida, hopefully we can all aspire to have that someday. Your estate will have to be opened here in Arkansas in Pulaski County because that's where you live. and there will be what's called an ancillary proceeding opened in the county in which your property is in Florida. So that is a double probate. It's not always the exact same amount of expense, but there is the possibility of having to do that double probate in both places. We can avoid that by having ownership by a trust, and you avoid probate in both places. I've mentioned beneficiary deeds. Not all states have them, but Arkansas does. And it basically is a deed like you would for normal property. And it just says that only effective upon my death, my house belongs to whoever you've designated. And that does transfer title, but only after you've passed away. And the person who is receiving your property takes it subject to liens and mortgages on the property. So they would have to refinance or be responsible for paying the mortgage, assuming the mortgage. And if they sold the house, any liens associated with the house would have to be paid as well. If you have rental properties, this is another big one. You can have an LLC in place or corporate structure. LLC is an easy one. Your LLC can be, it's a limited liability company, can be owned and operated by your trust. So put your rental properties into this LLC, that limited liability company, and it insulates liability for those properties only to the assets of the LLC itself. So you have a rental property that blows up and kills everybody that's inside. Their estates, are trying to sue. They would sue the LLC, but ultimately they would try to get to your individual assets that are not in that LLC. If you have this LLC in place, they would be limited to the assets in that LLC to satisfy the judgment. It protects your individual assets, including what's titled in the name of your trust, your bank accounts, and all of that stuff. So the next phase would be having or adopting children. This is a really major thing. You can name the guardians of your minor children in your estate planning documents, your general durable power of attorney and your will. So you can say who you want to take care of your children if you're not able to. Generally, if you're, obviously if you're married, it's probably going to be your spouse if they're the parent of that child. If you're divorced, it's probably going to be the parent of the child regardless. But in lieu of those people, you can say who you want to be in charge of your children and raising them. They would still have to go to court and get appointed as the guardian, but the court would give deference to your choice that you put in your estate plan. The guardian is always going to be entitled to compensation for their actions, for taking care of the kids. Not that they would have to accept it, but they're entitled to it. So you want to make sure that you're funding a plan to take care of your kids if you're not able to do that. Think about life insurance to generate income, to pay the caregiver or the guardian. What other assets would need to go into this trust or this entity to be able to help care for your child if you're not able to. You also want to think about supplemental needs planning. Does your child have special needs? Do they have Down syndrome or some other condition that would require them to have Medicaid or SSI or some other type of benefit? You want to make sure that you're planning in a way that would keep them eligible for their benefit. Children turning 18. This is one that lots of people don't think about. Turning 18 or going to college, you as a parent will lose control over your child. You can no longer make financial or healthcare decisions for them. So you want to make sure you have healthcare and financial powers of attorney in place for them. So either you or somebody else can make those decisions for them. You also want to start thinking about making sure they have beneficiaries on their bank accounts, or if they're going away to college, you want to make sure that all of these things are in place so you can take care of your kids if something happens to them. Heaven forbid they have a wreck on the way to college in Fayetteville. You might not be able to make medical decisions for them unless you have those powers of attorney in place. You also want to plan for financial or emotional immaturity, divorce, and creditors for your kids. So with proper trust planning, you can make sure that, of course, I've been saying this a few times, but that child that has a drug habit would have to be required to go to rehab or prove that they, have a drug test to prove that they're clean, or things like that. You can provide for provisions like that to where the distributions are metered out a little at a time, or restricted if they don't meet the qualifications. You can also, if they receive their inheritance in a trust, you can protect from divorce division. So if they get divorced from their spouse, it cannot be divided. What's in that trust cannot be divided in that divorce, wouldn't be available for that. And it also protects against creditor claims. So if somebody gets a judgment against your child, the creditor who has a judgment cannot access the assets of the trust to be able to satisfy that judgment. Okay, this is the part that nobody really wants to think about, but it is a reality. Sometimes children die. So you want to make sure that you're at least thinking about that. And there's the possibility of, maybe getting a life insurance product that, after your child dies, that's a huge grief process, and you may not be able to work. You may need to be able to supplement your income while you're going through that and dealing with it. And a life insurance policy is a good way to do that. This is also a personal thing for me. So you want to monitor their social security numbers. A few years ago, actually it's about 11 years ago, 12 years ago, my niece, Reed Hill, passed away at the Children's Hospital. She was about 18 months old. She had some developmental issues, and she was, in the hospital for a good part of her life. Shortly after she passed away, of course, our family's grieving. We're going through all kinds of, my sister especially was going through a whole lot. Well, they get notice that her social security number had been stolen. They had opened up credit cards in her name and had charged all kinds of things to these credit cards. So that was a big violation. My sister felt like that was a huge violation of that trust. No, not sure how it happened, but I think whoever did it was held accountable eventually. So I would say monitor the social security numbers, maybe credit checks for a couple of years after a child passes away, just for that purpose. So the next stage in life is going to be starting or owning a business and then selling a business. So business asset interests are assets of your estate. So you own corporate stock or you own membership interest in an LLC, those are assets. Just like a bank account, just like your 401k, those are assets. That is your entitlement to distributions from the company, from the business. Most of the time, your business interests can be owned by a trust, so that will pass probate, not have to deal with any of that. You want to make sure that you have your corporate documents in place for several different reasons. First, and this is not on here, but you want to make sure that you have the corporate documents in place that say how the company is going to be run. Because if you, let's say, using that illustration of the rental property blowing up and they're trying to come after your individual assets, if you have the corporate documents in place saying this is an LLC, this is how we're running it, and you're actually adhering to those quote corporate formalities, the court will be less likely to allow them to have access to your personal assets to satisfy any kind of a judgment against you. Those documents also will usually dictate how interests are treated at death, whether there's a right of first refusal for the partner to be able to buy back the interest in the business from the spouse or from the estate. You might have to open that probate estate to be able to process that, or the agreement can say otherwise as well. There are buy-sell agreements between partners that just say that if somebody passes away, that they're going to pay money to the estate or to the widow or widower for those business interests. And also, frequently partners will have life insurance policies on each other. And part of that sometimes that will be used to buy the interest from the spouse or from the estate, or it'll also be used to make sure that the business can keep running without that other partner's contributions. When you're selling a business, during your lifetime, it's quite possible that the value of the business has increased in value. We would hope so over time. So let's say you started this business with $0 and now it's worth $1 million. You want to sell that business and get your $1 million. Well, there is a gain, a capital gain of $1 million. There's the possibility and probability that you will have to pay a capital gain tax on that $1 million. And it can be 25% or even more. So that's $250,000 of gain that you might have to pay in taxes. There are possible tax saving strategies that can avoid that capital gain tax issue. And if you want to hear more about that, give us a call, we can talk about it. If you are selling a business after somebody passes, there's what's called a step up in basis. So in that same illustration where we had $1 million worth of gain. It was worth nothing when you got it or formed it, and now it's worth $1 million. Your basis is now $1 million instead of 0. So there's no gain after that. So you would not necessarily have to pay that capital gain tax because it's worth $1 million. You got that full step up. That same pending legislation that I referred to earlier has the possibility of doing away with this step up in basis. So that means that even after death, it is possible, if they pass it, for that step up in basis to go away, meaning any sale of the business would trigger some sort of capital gain on that $1 million that we were illustrating. The next stage of business or stage of life will be retirement. I'm not going to spend too much time on this because I want to get to the long-term care one real quick. I know we're running out of time a little bit. You want to review and update your estate plan. Make sure you have sufficient assets that would provide income for your retirement. Update your beneficiary designations, and always seek the help of a financial advisor to help develop a plan. Some people are sophisticated enough to do that themselves. I am not, so I will definitely be checking with a financial advisor to help with that. The next stage of life will be planning for your long-term care. This would be in an assisted living or a nursing home situation. So, everybody knows that this is an expensive process, but what is the average cost of care? So here in Arkansas, the average cost of care is $5,505 a month. That's a lot of money. Lots of people don't have that kind of income per month, so the chances are they'll have to spend their assets to pay for it. How do you pay for it? There's several different ways. You can private pay, which means you just use your assets and spend them down, or use your income and spend down your personal assets. That dwindles down your estate to and minimizes what you'll be able to pass on to your beneficiaries. Or you can get Medicaid to pay for it. And among other things, Medicaid is the quasi-federal state program that can pay for nursing home care or assisted living. They also right now have the ability to pay for in-home care, but they're trying to do away with that. I have not verified whether they've been successful with that yet. So the way that Medicaid works is that there is an income and asset limit for it. So if there's only one person needing the Medicaid, they have to have less than $2,000 worth of countable assets, and I'll get to that here in a minute. And if it's a couple and the non-Medicaid spouse is not going to need Medicaid, they can keep $130,380 worth of countable resources. And if both spouses need Medicaid, then they have to have under $3,000 worth of countable resources. So when I was mentioning countable versus non-countable resources, a countable resource, just think of, there are exceptions, but think of anything that can be liquidated to pay for Medicaid or for long-term care, whether that's your bank account, your IRA, your annuities, cash value life insurance policies, those sorts of things. Non-countable assets are assets like your home, up to $600 and something thousand worth of equity, prepaid funeral services, cash value life insurance under $1,500, and a car of reasonable value. They don't really say what reasonable value is, so it could be a Range Rover. I would think that could be done, and several things like that. Those are non-countable, meaning they don't go towards your qualification for, let's say, the non-Medicaid spouse keeping the $130,000 of countable resources, or the Medicaid spouse needing $2,000. So there are a couple of different financial products out there. Of course, there's long-term care insurance that could be used to pay for long-term care instead of needing Medicaid, but that's very, very expensive and hard to get these days. There are also life insurance and annuity products that will allow you to convert your cash or even your retirement accounts without triggering tax consequences into these products that would pay for the long-term care. Anything that's left in those products would go to the beneficiaries that you've designated, and both of those are instead of having to qualify for Medicaid. There are two different kinds of planning for Medicaid. One would be the pre-planning, which is at least 5 years out, and Medicaid has a 5-year look-back period, into your past to see the gifts that you've made. If you have made gifts of your property 5 years and 1 day ago, the Medicaid will not see that as a disqualifying gift. The way they do it is if it's made within that 5 years, they see the value of that gift, they divide it by a penalty divisor, and that will equal the number of months that you'll be disqualified, and you have to figure out how to pay for long-term care in the meantime. Crisis planning is planning when you need it now. So you just had a wreck, you're in the hospital, you need to go to rehab, you need Medicaid to pay for it. That's a series of gifting and spending down your assets to get to those asset levels. This can also include converting countable resources like cash into non-countable resources like home equity. Let's take your IRA or let's say the cash in your bank account, pay down your mortgage as much as possible. And it's a series of those kinds of things. Medicaid, if it does pay for your long-term care, is entitled to what they call estate recovery. So they paid for your long-term care, they're able to then receive from your estate an amount up to the cost of care that they expended for you. And the way they do that, and this is one reason why your home is a non-countable asset for Medicaid purposes, they attach a lien to your house. And if that house is sold, then they will get paid an amount up to the cost of care that they expended. That's a whole lot of information. I got one more stage of life to go, and I will do it quickly. The death of a spouse or partner, you want to make sure that you are reviewing your assets and beneficiary designations. Hopefully you do have your plan in place, but if not, update it, get it in place, and make sure that you can avoid probate and all of that we've talked about. Our probate or trust administration or both needed, because in some instances, like I was talking about with my grandparents, they had the trust, but they still had to open the probate estates in order to do it appropriately. Contact an attorney, even if it's just for a conversation, just for having somebody tell you what the next steps are. There may not be any next steps, but you're still dealing with that fog. Just sit down with an attorney and let them help you. Of course, update your beneficiary designations, and if your spouse had a retirement account, make sure that gets rolled over to you, and make sure you designate beneficiaries on your rolled over inherited IRA or 401k or whatever it is. It'll be an IRA at that point. That actually concludes the different life stages that I wanted to talk about, and I'd like to open up the floor to any questions if somebody has some.
Okay, we do have several in the chat. First, can you use a beneficiary deed instead of a will?
Yes, you can, and that would be on your home. So if you had a beneficiary deed in place and you said, only upon my death, my house belongs to so-and-so, my son or my daughter, that would completely avoid the probate process. You would still want to have a will in place as a backup for anything that needed to go through your probate estate, but if you had the beneficiary deed in place just for the house, and that was the only asset, you would not need to use the will.
What would happen if you didn't have the money in your estate to cover the cost and attorney fees?
For estate planning or for, I mean, it depends on, for like probate estate planning, probate fees?
I think so. That question came up about when you were talking about that.
Right, so there are some ways to, in that kind of situation, what I usually will do is I will accept payment on the back end. So if you don't have money to come up with my retainer or to pay me along the way, I might say, okay, well, there's a house that needs to be sold, or there's going to be some cash that the estate gets. I'll get paid once the estate is settled, and we'll ask the court to approve the attorney fee of X number of dollars, and usually it's a reasonable fee, and the court will allow that. So it'll be paid from the estate assets at the back end as opposed to along the way or on the front end.
Okay. Let's see here. Okay, when you say write everything down, do you have a list of the things we need to write down?
I do not have a specific list that I have written down for that purpose. But if you can think of anything, write down your mortgage loan number, the balance on it. Write down any account numbers that you have for bank accounts, what bank it's at. If you have passwords to get into those assets. Same thing with email addresses, passwords to those things, any kind of account that you have. Like I said earlier, your Facebook account, you want somebody to be able to go in there and shut it down. You know, any kind of password you have, any kind of account that you have, write it down and make sure that somebody has at least access to that. Sometimes people don't want to write it down and have it just sitting there. What I was trying to get my friend Robert to do is type it into the note function on his cell phone, so it would lock when he locked his phone, but I had his PIN number so I could have access to it later. He just wouldn't do it. So.
Okay. You said trusts are slightly more expensive than wills. What is a ballpark someone would need to set up something, basic fees?
Okay, so of course, every lawyer is going to say it depends. But I'll just say what our fees are, what we start at. So our will-based planning will start at around $1,200 per person, depending on complexity. And that would actually include a beneficiary deed. If you were going to do a beneficiary deed, there's a $25 filing fee in addition to that. So $1,225, you have a basic will plan. If it gets more complicated through the will plan, it can be more, of course. And that would be per person. If you do a single revocable living trust, you can look at starting at around $3,250. But again, you're avoiding that $12,365 in the probate, right? So it's a little more expensive, but you're saving money on the back end. Again, increases for complexity as necessary. If it is a joint revocable living trust for a married couple, that is going to start around $3,650. And if you do separate trusts for a married couple, or just a couple period, you would probably, our starting point would be around $4,250.
But
you're saving all that money.
Would a pre-arrangement with the funeral home be something that would go along with estate planning, or would I put that with my will?
That is actually a part of estate planning. The prepaid funeral services, that is, when we referred to elder law earlier, that is the whole Medicaid spiel that I gave just a minute ago. Having the prepaid funeral be a non-countable asset, that is a part of estate planning. And it is just ensuring that all of that is prepaid. It's not going to cause any trouble. With my friend Robert, I was able to do funeral pre-planning before his passing. So that is a part of the estate planning process, if that is something that you're interested in doing. If you're not interested in doing that, then your loved ones can use your estate's money to be able to pay for the funeral, pay for all that kind of stuff through that process. I hope I answered that question.
Right. And one final question, what paperwork would I need to do to protect my child with special needs or disabilities?
Right. So, let's say if your child is on SSI, which is Social Security insurance, or SSI or SSDI or whatever, you can actually become the third-party guardian essentially for the purposes of that Social Security to be able to accept the payments on that child's behalf. As far as, if you were to pass away, you would want to set up what's called a special needs trust that would allow them to stay qualified for the benefits and, even pay for their caregiver, that sort of thing. And you can have a standalone separate special needs trust if you want to. Those are probably going to run around, $2,300 or $2,400 for a standalone one. But the planning, if you do a regular trust-based plan, from us, you're not going to get this from everybody, but from us, all of our trusts include backup special needs planning or even deliberate special needs planning. So if we don't know a beneficiary is going to need special needs, we're going to have that, well, if they need it in the future, they're going to get it in a special needs trust as opposed to a general needs trust. If we do know specifically that they have special needs, we will make specific provisions to only allow them to have it for the special needs purposes or supplemental needs purposes. There are also, this is not necessarily protecting in a way it is, there are things called ABLE accounts, ABLE accounts. which you can actually allow people to make gifts to these accounts, and the special needs person, individual, maybe it's certainly an adult, can have access to those funds and be able to use those independently if they're able to do those things for themselves. And that'll still allow them to qualify for their benefit.
Okay. Right. Well, thank you, Kevin. This is very informative. I want to let everybody know that we will have grab and go bags with information from from presenters from all of our 4 programs in this series that will be available starting tomorrow morning on a first come first based service basis at the main library, the Williams Library on Chester, and the McMath Library on John Barrow Road. Thank you, everybody, for attending tonight. Thank you again, Kevin. Thank you to our friends at the Treasurer's Office for getting this set up. And remember, all of these programs are available on the Central Arkansas Library System's YouTube channel and at the Treasurer's Office. And with that, everybody have a great evening.
Thanks, everybody.